All right, Senator West, we're going to start off with your bills. So let's start off with Senate Bill 735, and then we'll go to 820.
Senate Bill 735, State Government Notarial Acts Remote Notarization. This bill authorizes remote notarial acts with respect to wills and trust instruments and clarifies the application of specified requirements for credential analysis and identity proofing as they pertain to remote notarial acts. Also, the bill specifies that if a notarization of a document is in line with a certain executive order that was issued during the COVID pandemic that authorized remote notarization, they must be deemed valid if the notarial act occurred during the time that the orders were in effect. Additionally, there is a sponsor amendment in your packet. That's Amendment 653724, and that establishes procedures for remote notarial acts.
If I could just explain, because there are a number of people were not present when I presented the bill last week. So last winter, when the pandemic hit, the governor, of course, issued his emergency declaration. And then the Wills and Estates section came to me and said, we're having problems. A lot of our clients want to create wills, and they don't want to be physically in the presence of other people, much less in a small conference room down at a law firm. So they want to do them remotely. So I put them in touch with the governor's attorney, Mike Padone. And the two of them and the Secretary of State negotiated language, which was then incorporated into two executive orders, one dealing with remote notarizations, the other dealing with remote executions of instruments. The governor issued both of those executive orders, and pursuant to those orders, wills have been executed remotely for the past year, as have notary public notarizations on key legal documents. The problem we have now is that because the procedures in those executive orders did not require in-person execution of the documents or notarizations, when the governor rescinds his emergency declaration, which will happen presumably sometime between now and the next legislative session, both of those executive orders will evanesce simultaneously with the rescission of the repeal of the the emergency declaration. And at that point, because all those instruments were executed pursuant to the executive orders, which are themselves inconsistent with Maryland law, which requires personal presence, in-presence execution, all those wills and all those notarizations are subject to being attacked as being invalid. So it's essential that we pass these bills, or some variation of these bills certainly, because they harken back retroactively to the beginning of the pandemic, and retroactively, as it were, validate all the wills and other instruments that were signed in accordance with the two executive orders. So, so that's why it's so essential we pass these bills. Now, what happened more recently is that these were drafted by the Estates and Trust section in concert with the governor's lawyer. But the real property section of the State Bar Association took its own look at this legislation and concluded they had problems with it. So in the 2 weeks prior to my presentation of the bill, the representatives, the leadership of both sections of the State Bar Association met intensively and negotiated in each case, this bill and the next one we're going to consider, a lengthy amendment which would satisfy the needs of the real property section while preserving the essential needs of the Estates and Trust section. So both bills need to be read in conjunction with their amendments. I will tell you, they're very complicated. They're designed to be read by lawyers and applied by lawyers who practice almost exclusively in these areas, both real property and estates and trusts. So Heather's explanation of the bill is correct. It's very simplified. If you try to read the bill with its amendment is probably, this bill is probably 11 or 12 pages long. The bill we're going to get to next is much longer than that. and it's complicated. I do have Michela Muffaletto, who was my witness last week, on standby. So if anybody has a complicated question, we can pull her in and get her to answer the question for you.
Okay, so right now we're on 735, which is the notary. So last year or whatever year before, we passed the remote notarization bill, right?
Yes, we did, but I will tell you that the Wills and Estates section, Estates and Trust section, at that time, didn't see the need for remote notarizations, and the real property section negotiated this to their satisfaction. So now, of course, everybody realizes with the onset of the pandemic that they were short-sighted and that they should have all signed on and worked hard on the remote notarization bill. So this represents a slight redraft of the bill we passed, was it last year? I think it was last year.
I think so.
In order to accommodate the bill to the needs that the pandemic has visited on our civilization.
Okay, so we're amending the remote act from last year.
Right.
And we're amending it because we learned stuff since last year that probably should have been included then, but this is basically an update to the Remote Notarization Act.
That's exactly right.
Okay. All right, and the amendments were all worked out by the various bar sections, right?
They've been signed off on by the leadership of both the Estates and Trust section and the real property section.
Okay. I mean, the notary piece would, I guess, have much more relevance to the real property section. I mean, some for the estates and trusts, but mostly for the real property section. That's your big notary,
That's right.
your notary section, not so much your estates.
And
So-
if I can call to your attention on page 5 of the amendment is the key, what I think is the key language, which says the Secretary of State may adopt regulations which would specify more particularly procedures for notarizing documents for, in the case of a remote signer, a remote witness, or the confirmation of a tangible record by a notary public.
And are you moving the amendment to the,
I don't have the conformed amendment. I have the actual amendment and the original bill.
so the amendment is 653-724,
Yes,
and it's got a reprint with it?
yes.
So you said it's not a conformed amendment, what do you mean?
And I don't have the reprint. Near the end of the amendment is section 18-222, which is.
Senator West, you should have in your packet, behind the amendment, you should have the
reprint.
The reprint.
I should, okay, is this
Mine's stapled to the
my
amendment,
packet?
653-724.
There we go, I'm sorry. Thank you. Senator Sidner's, let me use his. So the language I'm talking about in section 18-222 is found at page, do you find it, Shelley? Where is it? After page 3 of 5. Yes, there it is. And that gives the power to the Secretary of State to issue regulations which prescribe the methods for the reasonable confirmation of a tangible record, et cetera. So after we're done with this, the Secretary of State can issue regulations tailoring the actual operations of this to the needs of the various participating parties.
Okay, so my only surprise was that I thought that the remote notary statute we acted was a model statute. Wasn't that the case? This is a lot of amendments to what I thought was a model statute, but maybe I'm wrong on that.
I think it was a model statute. We all passed it last year, but no one, when we passed it, no one expected that this pandemic was going to hit.
Yeah.
And that forced everyone to take another look at it and to realize that under the clear light of day, with the pandemic reigning, that the language that we passed last year was insufficient and needed to be amended.
Okay. All right, thank you.
Sure.
So a lot of the amendments, they deal with tangible records, which, according to the testimony that was submitted, it just caused some confusion about it's a physical record that's being notarized, but may not being actually signed at the time. And then you may have two people who are signing the same tangible record, but they're in two physical different locations. So that's what the amendments are trying to get, more of like the technical details teased out. And then Senator West is correct that the amendment also specifies that the Secretary of State shall adopt regulations specifically on these records.
Why these bills are so complicated is they have to consider about 18 different permutations. You have the testator in person, you have witnesses missing in different places. You have witnesses in person, you have the testator in a different place. You have the notary in a different place, but the testator present in the room. So you've got to accommodate all these different people who are going to be operating remotely and make it all fit together. It's like a puzzle. And I believe, my understanding is that the leadership of both sections of the State Bar feel that they solved the puzzle and that all the pieces are in the proper places.
All right, Senator West, I had the same conversation with the Bar Association, I think 2 days ago, yesterday. Do you want to move the amendment?
Yes.
All right, is everyone okay with that? All right. Further discussion on, we're just going to do this one at a time, so 7:35 right now, okay? Senator West, you have a motion?
Move the bill.
It's been seconded.
We already adopt the amendment?
We just adopt the amendment, yep.
Okay, so now we're moving the bill?
Yes.
And I second the bill.
Okay. Everyone's okay? Excellent. All right. Senate Bill 820.
So I won't need to give the entire prelude to this that I just did. Bills really go hand in hand. The difference about this bill is it, as originally conceived, it did not cover real estate transactions. So the real estate section got actively involved because this bill talks about the execution of wills, powers of attorney, and advance directives. They were very interested in the powers of attorney. These days, in many cases, maybe even most cases, real estate transactions occur, and the people who are signing, both selling the property and buying the property and providing the mortgage on the property, are not physically present in the room. So what they do is they'll sign powers of attorney to permit somebody else to sign on their behalf. And so the real estate section of the State Bar was extremely concerned about these powers of attorney to make sure that they would be written in such a way as to allow title insurance to be provided on the property, because there would be no question but that the signatories on the deed and the other instruments are the proper people and properly signed, and would not be able to come in later and claim that the documents had been incorrectly signed. So that's why they got very involved in this. And again, it was for 2 weeks, representatives of those two sections of the Bar Association worked really hard on this very lengthy amendment, which you'll find in your packets. And at this stage, they're all totally copacetic with what they accomplished. I didn't get the amendment much before I presented the bill last week. So this is of recent vintage. But from my conversations with them, I believe they did a good job on it, and they're all satisfied with what they accomplished. And if there is something that's not, as we learned last year with the notarization bill, it had to be changed this year. And I suspect in future years they will discover that this bill needs to be tweaked in one way or another. But I think they've done the very best they could to come up with a good finished product, and I would recommend that we adopt it.
I apologize for this. I do. But I just want to be clear of everything that this encompasses. So can you just slow walk me through everything that we are allowing now to?
I do have the conformed bill here, so go through it. It starts with wills, and for the first couple of pages, it deals with the execution of wills, and various of the parties are executing it remotely. So the witnesses, Senator Carter, do you have a copy of the conformed bill? Okay. So the first several pages deal with the remote execution of wills by various parties to the wills. So you've got the attorney in the attorney's office, who has to prepare a certification that it was all done properly once the will's been signed. You've got remote witnesses, you have a remote notary, you have a remote testator, or some combination of the above. And that's what's covered by pages 1 through, let me get it right. Hold it. 1 I think it's 1 through 7 of the bill. And then, maybe it goes further than that, I'm sorry. Because you get some of the same definitions a second time. The second part of the bill deals with powers of attorney. And there we go. By the time you get to page 11, you're on the powers of attorney. That actually starts backwards on page 8. And then the last section you come up with is the advanced directives. And these are the documents that people sign in advance of their incapacitation or death. And so you're dealing with exactly the same considerations for all three sectors: wills, powers of attorney, and advanced directives.
The advanced directive would be remote, they wouldn't have to be physically present?
They would not have to be physically present. Yes.
My initial thoughts are of really great concern for these reasons. One, I recently saw where one of our colleagues, a member of the bar, was disbarred for having falsified being a witness to a will, and that wasn't remote. It was she claimed that she was present, and falsely claimed that she saw the decedent sign the will, and I just feel concerned. Sometimes it's in the interest. It could possibly be in the interest of an attorney to claim that they saw that, but that's not my biggest issue. I remember when my mother got sick, and we were encouraging her to sign all of these things, advanced directives and everything. And I was very much in a state of denial and not wanting it to be the case. And my mother was making it clear, I don't want any of this, I don't want any artificial supports, I want to just go when it's my time. But I did not agree with her. And of course, because, I'm not a dishonest person, but I did sit down with her and say, Mom, are you sure you want this? And let me tell you what this means. And, I attempted to persuade her otherwise where I thought it was important. I'm just concerned about, not being in the presence and having someone like me around that thinks I know better than my mother. Do you see what I'm saying?
I see what you're saying.
How do we? I mean, I know we can't legislate for dishonesty. I know that.
No,
but these are
same
emotional situations where people are trying to do what they think is best for someone.
And
Senator
problem
West, also just to tag in, because I don't want to do a separate question, but I'll give yourself the opportunity to address the same concerns were raised in the Catholic Conference letter, and you spoke a little bit of this during the hearing, but again, the element of just the door for coercion, especially in light of our recent debates on the floor, elderly populations. So this is the type of exploitation we're talking about. So could you just address that, Senator Carter's concerns, but also the specific concerns that were raised with the Catholic Conference as well? Yeah,
sure. So there's always the possibility of undue coercion. Even if the document's going to be signed in the attorney's office, the daughter of the older lady who's going to be signing the documents can bear down on her mother in the car on the way to the attorney's office and convince her mother that she ought to sign a document that reads such and such a way. That's the case not only with powers of attorney, with advanced medical directives. It's also the case with wills. People who sign wills can be unduly influenced by one family member or the other who has their attention. So the fact that it's being signed remotely as opposed to in the attorney's office it might to an extent exacerbate the problem, but the problem is there, irrespective. And So increasingly, well, certainly during the pandemic, the alternative of requiring the person to come down and sit in a small room with the attorney and other witnesses simply wasn't acceptable. Even after the pandemic is over, there are going to be people who, for example, have always lived in Maryland, but they have a house in Florida, and the older couple moves to Florida, and they want to make a change to their will. Well, they don't want to fly all the way back to Baltimore to do it. They want to be able to do it remotely. So, yes, I can see the problem, but I'm not sure there's any way of getting around the problem other than having maybe a mental health professional attend the person signing the will remotely, and I don't think people want to pay for that. And I don't think we should require them to have such a person attending them when they're signing a document like this. We ran into the same problem with the Death with Dignity bill. I don't know if you recall that. This the same argument that someone could be unduly influenced to sign a document saying that they want a fatal prescription. And the Catholic Church was against it for the same reason, the possibility of undue influence. If you're going to allow someone to sign a document, whether in person or remotely, you've always got the problem of undue influence. I don't see how you get away from it.
Yeah, that sort of echoes my concern is that, I don't remember, it was this term or last term, we had a couple bills in, and the one that I remember was Casey Kasem's daughter came in here, but we had like 2 or 3 bills like this year, or that one year, dealing with basically people who were elderly and were, had dementia or something like that, and then they'd had family members redid their wills, redid their powers of attorney, and there was this huge fight. Like Casey Kasem, like that story, he was literally like kidnapped and secluded and taken away. As soon as I saw that, that's what I worried about, because we were trying to target at that a couple years ago, where people were taking advantage of elderly people and redoing their wills and powers of attorney. And that was my concern with this, is that it allows it so the witnesses aren't around, and so it seems to exacerbate what the problem we heard a couple of years ago.
Serious problem. I'd sort of like to get Ms. Muffaletto on the phone because she always wrestles with this. This is always an issue when you have people signing wills or other instruments that are going to affect the disposition of their property. Is it possible, Sandy, to get her on the phone so she can address this issue?
Maybe we could have her draft something in response to the questions that were raised here today. And Senator, I think that'd probably be most appropriate.
Okay.
We can, Senator Castley.
Yeah, my reading through the amendment here, my concern is that, this is not rare. In my own little law practice, I don't do a lot of wills, but I have twice had instances where, you prepare the will based upon the family says this is what grandmom or granddad wants to do, or mom or dad. And so you prepare the will, you say, now bring them in and we'll sign it. When they get there, you're like, I'm sorry, they're not there. You should have come in 2 years ago. Dad is not there. I cannot have you sign this. I cannot do this will because I'm looking at him. It's just not the level of fidelity that I need to see in this old guy to know that this is his free will. But beyond that, if the witnesses, here's my big problem with it, the witnesses are not with the testator. So I'm signing my will. There's a witness in that town and a witness in that town, and they, I guess, can see me on their screen, but they don't know who's over here or over here or over here, just outside of the cameras. They don't know that Aunt Susie, with her glaring, stern look, is looking at the old guy and saying, freaking, the caretaker's not there saying, give him the glaring look. When people, as the witnesses on a will, traditionally those people they walk in and they say to the testator, hey, Jim, how you doing? And Jim says, no, I'm good, Sue, so we're here to... They don't read the will. They don't know what's in the will. That's not their business. Their business is that they know Jim, and they spoke to Jim, and Jim seemed alert, and this was Jim's his act of free will. They have no indication that Jim wasn't alert, that he was being threatened, and That's what they attest to by that presence. So, and that's why frequently in these cases, it might be if the person's in the hospital, the nurses may be the witnesses, because they're not saying that this is what they're not saying that what's in the will is right. All they're saying is, Jim signed this will, and when I was there with him, I had every indication that this is what Jim wanted to do. Nobody was threatening him. He was awake. He seemed, I'm not a doctor, but he sure seemed alert to me, and that he was compos mentis and moving. So I just have a challenge with this, with the electronic. It just scares me a little bit. And I mean, the whole thing would be different if the witnesses had to be with the testator, which shouldn't be too difficult unless he's in a bubble or something, to get two witnesses who are with the testator when they sign. But that just troubles me.
So, Senator West, you want to hold this until you have an opportunity to consult with Ms. Muffaletto?
Yeah, why don't we hold it? I'm sure we're going to have voting sessions later in the week. I'll get back to her this afternoon after we're finished here and ask her to prepare a statement addressing these concerns.
Got it. I mean, she did prepare like a 4-page memo for us, but none of them were on point for some of the issues that were raised.
Right.
So.
Okay.
Okay. All right. So we'll go on to Senator Carter, Senate Bill 401.
This bill alters the period of time before the expiration of a lease that a landlord is required to notify the tenant of the intent to terminate a periodic tenancy or tenancy for a stated term. The bill applies to any lease executed on or after the effective date of the bill and any residential lease that was executed before the effective date of the bill if the lease has expired and resulted in a holdover tenancy on or after the effective date. So there are a few things in your voting packet. The one is a portion of the fiscal note, and then it has my handwritten notes which specify what the bill's terms are compared to the current law. Additionally, there is a copy of the House amendments, the House bill as amended, and that and Senator Carter had introduced an amendment which was not included in your packet, which would do the same to conform the Senate bill to the House bill. There aren't substantive changes really. It's more of converting references from weeks and months into days. So instead of 6 months, it would be 180 days. 1 month is 30 days, and 3 months is 90 days. And then there's also an amendment by Senator West, which was similar to Senator Carter's amendment, where it struck some references from months and converted it to days.
I would only say that, so I've looked at the House amendments and also my amendment and Senator West's amendment. As you said, they're all really technical amendments. None of them change the substance of the bill. The point of the bill is to create uniformity with the required notice for tenants in these cases. Only 2 jurisdictions right now recognize the amount of notice under the bill. I would move the amended bill, the bill as amended by the House, which I think is the same, includes the amendments from Chris West and myself, just the same, they are the same concept as what was passed in the House, I believe, right, Heather? Or is there something more?
No, that's correct. They're similar.
Thanks. So I move the bill.
So they're identical.
Amended.
Second.
You hit the microphone.
Oh, second amendments. Can you hear me?
That's right.
Okay.
Second amendment. Coming on my side. All the Republicans cheer about the Second Amendment. All right. So, I'm unclear. So, do we have? I'm not looking at this amendment. So, what is? It's just a.
It's to conform to the House bill. You have the House bill in front of you.
Yes, this is the House bill.
Yeah. So I just got Senator Carter's amendment late, so that's why it wasn't included in your packet.
Got it. Okay. So you want to? So the motion was to adopt.
The House.
What's the name of it? Can you just get the number of the amendment?
Yeah, so the amendment is 523821/1, conform to the House.
Which conforms to the House, and everyone has the House bill in front of them.
Yes.
Okay, and then everyone has this summary about,
Yes.
okay, got it. Is everyone okay with just adopting that amendment? We can work off of that? So it would basically just be, so the House bill before you is what we're going to be working off of.
Sandy, could you send
There
me?
were any additional amendments to it.
While you're at it, how, could you send it to me too? Sandy, me too. I'm over here. Well, he's in the whole packet.
Senator West?
Just the days, what it drops it down to.
Yeah, I mean, yeah, so the amendment just does what it says. It just converts months to days and then weeks to days as well. Yeah. I mean, Senator West's amendment made a more technical amendment by striking a reference of the current year, which it was made in one location but not another location. So I did discuss it with review, and it wasn't necessary if the bill is okay without it. If you wanted it in there, it could be included. It's not necessary though, from a technical standpoint.
Senator West, you going to press it or what?
Does anybody have any opposition to it?
Senator Carter?
If the view is it's not necessary, I won't press it.
So looking at Senate Bill 401, and I assume we're adopting the written in parts here. So what this bill does is extends from 1 month the notice that the landlord has to give the tenant to 2 months. Is that the extent of what this bill does now?
No, so it's or tenancy from month to month. And the tenant has resided in the same property continuously for 2 years. That's when instead of 1 month, the tenant needs 2 months. However, if the tenant has resided in the property for more than 2 years, instead of 1 month, they get 3 months. Or under the bill as amended, it would, what would that be? Instead of 1 month, 30 days.
And these are month-to-month leases, you said?
No, it's a written lease for a stated term in excess of 1 week, or a tenancy from month to month. So
So if it's a month-to-month lease and you live there for two years and 1 day, I got to come in, I got to give you, I can't just say, hey, look, next month we're done. I got to give you 3 months' notice.
correct.
Yeah. And so and then the one above that, lease started 1 week, month to month. Oh, and I see less than 2 years. Instead of 1 month, I got to give you 2 months.
Correct.
Hey, why? Because you say people can't find a new place in a month? Is that the whole purpose of the bill? Jill?
Yeah, the purpose of the bill is just to give more notice.
Can you move the mic, sorry?
3 months is a long time.
So these are, for my understanding, they're not necessarily failure to pay.
No, I know. It's just like I don't want to rent the place out anymore. I'm going to sell it or something.
Right, so the goal is
That's
to
a long time, though. 3 months
90 days.
for a rental. I got to give you 90. I got to give you 3 months to go find another place. Like I want to sell the place. What if I don't? What if I, as the person that owns it, what if I lost my job and I can't afford the place anymore? So I'm like, I got to sell it. Nope, sorry, you got to hold it for 3 months. Can't pay the mortgage, but you know, like, okay, what if I got 2 properties? I'm just saying there's 2 ends of this. I got 2 properties, right? I got the house I live in and then I rent one. I lost my job, so I can't even pay my own mortgage anymore. So I got to sell this place. Now I got it 3 months, I got to hold it so somebody could find another place.
Yeah.
I mean, that's a
First
little,
of
that's
all,
like, that's,
you're getting, actually, it's a benefit because you're getting the rent on the place while you're holding it. But, I mean, the goal of this.
well,
is
you're assuming the rent is covering the mortgage. We don't know that. It should be, but we don't know that.
The goal of this is to keep people in homes and prevent them from being homeless unnecessarily. And what we heard from a lot of the advocates for the tenants was that, especially during the pandemic, where there was a moratorium on evictions, that the loophole that was being used was this, and that notice actually was not only often too short, but it was actually done in ways that tenants weren't always adequately notified. Like, it might just be like through an email that you receive, and it may not even be like an email that you check, so there were notice issues and there was also time issues. that we heard
But if
about.
but back to if you own only 2 properties, you lost your job, you're going to lose everything. You've got to liquidate that rental property in order to survive. The landlords also have issues. Not everyone who rents is like some mega landlord that owns an apartment building. A lot of people that rent are, quite frankly, I almost did it, but I didn't want to get caught in the risk of it. When we moved from one house to another, we almost did it, but I just thought if something happened, I couldn't get caught for 3 months holding both mortgages in a bad situation. So that just strikes me as a little bit much to say you need 3 whole months to find a new place.
Well, I don't think that there's actually a requirement that you have to evict before you can sell. Oftentimes a new purchaser will pick up the place with the same tenancy. I mean, that's an option that's out there.
Nobody wants to buy a house with a bunch of tenants in there. They want it out. They want a home inspection to come through.
I'm just saying, it's just not a mandate. It's
I mean,
not a mandate.
when you buy a house, you do a home inspection. You're like, oh, who's this? Hey, buddy. Hey, how are you? You're still living here? Great. That's not how it works.
Well, this isn't, what you're talking about is not owner occupied anyway. I'm just saying, there's all kinds of scenarios. A lot of people are buying stuff for investment properties. They're happy to have a tenant already in there. That's true.
So I'm sympathetic with what I thought the goals of the bill to be, but then you seem to indicate that the goal of the bill is to provide actual notice. If the goal of the bill is because people aren't being properly notified that at the end of the lease will not be renewed, then why don't we create legislation to firm up the notice that is provided? So instead of an email, you have to post something conspicuously on the door, or you have to have certified mail. So, and so if that's the problem, there's an easy solution. The second concern I have is I appreciate what council has done here, but it's unclear what notice the tenant has to give in these circumstances. If you're creating a situation where a small landlord has to give 2 months' notice to vacate or 3 months' notice to vacate, but the tenant can give a month's notice to vacate, that seems to be fantastically uneven. So if we were to move these together, it would provide some consistency between the landlord and the tenant. I don't know what the answer is, and perhaps council can provide that answer. But here you're providing a real disparate treatment between two people who have entered as equals into a lease together.
Maybe, I haven't been a renter, I don't even think I've ever been a renter, to be honest with you, so it's not a personal experience that I have. However, it is my understanding from people that I know that have rented and clients that I have, I've never seen a tenant create a lease. The leases that I've ever seen have always been landlord-created leases, and so thus those landlords that create the leases tend to spell out the rights of landlords and tenants, and they tend to be favorable to the landlord. So I'm fairly certain the lease itself would be capable of spelling out what requirement would be given to the tenant. What our goal here is to make it more fair for those people that have less power in these situations. And that's the reason for legislation. There's still going to be a written lease, and that lease is going to be generated by the landlord. So I don't think that us spelling out the tenant's rights is what we need to do. I think that we need to trust the landlords to continue to write leases that are favorable to them, but we need to look out for the other side. We haven't had landlords running in here saying, we need tenants to give us more notice, but we have had advocacy groups and others coming in and saying that we need, one, uniformity across the state, and two, we need more notice in these situations before people are evicted.
We'll go to Senator Jackson and Senator Cassidy.
So thank you, Mr. Chairman. I'm actually trying to understand the bill. I do have rental properties, and I think, so is there a problem with 30-day notice?
Yes.
What's the problem with 30-day notice?
It doesn't often give people enough time to secure new housing, and they find themselves falling through the cracks and often could wind up homeless.
I think, well, I guess so. Let me reframe my question. So,
And so
if-
there are places that don't have, that already have a longer notice, but this isn't, 30-day notice is still an option depending on the term of the lease.
So we typically rent on an annual basis, and a couple of months out, we make contact. Do you intend to, or would you like to extend your lease, or the person says, this is to advise that my lease ends on March 31st, and I will not be seeking, to continue to lease. They have to do that 30 days out. So I guess when we've had an occasion, the properties are in the city in D.C., but we've had occasions where someone's job took them out and they had to go, and we were not okay, but we were okay when they gave a 30-day notice to say, hey, look, my orders say I have to vacate, and it took us a while to be able to prepare the unit for someone else to come in, but I mean, we know that's part of doing business. 3 months is a lot. So if I have to cover properties in the city, DC's not cheap. If I have to cover, or anywhere, it's not cheap, but if I have to cover those mortgages, 3 months is a lot. And I mean, so, landlords typically file after 3 months of not receiving payment. And, we've heard the complaints over and over again from, I certainly have in my line of work, but I've heard the complaints of how far it puts a landlord behind not being able to collect rent for 3 months and having that property stand dormant. So can we find a compromise here?
What's your suggestion? Go back to what we already currently have that isn't working for everybody? I'm just asking.
That's not what I said. I said I asked
Well,
for a
I mean-
compromise. I'm trying to help your effort. I mean, you could do 45 days.
Then we'll go to conference and it'll become 2 months.
Can I pitch on a possible compromise? So council's looking this up, but I believe Montgomery County passed a municipal law, or maybe it's in statute, that a 2-year lease has to have a 2-month notice. In other words, a traditional 1-year lease stays at 1 month, but when you double the lease term to a 2-year lease, which from time to time you see, then you double the notice term to 2 months, which makes sense to me. I mean, someone's in there for 2 years, it starts to become a little more of their place. It's not, but it starts to feel a little more like home, and they need a little more time to set everything up to get out of there. And so I think that's what Montgomery County has done. The sky didn't fall for landlords. That seems to me to be a reasonable place to land for some of these longer-term leases.
Wanted to explore the provisions that we haven't discussed, that on page 4, lines 23, it says, in the case of tenancy from year to year, including tobacco farm tenancies from year to year, but excluding all other farm tenancies. I guess my first question is, why are we distinguishing between tobacco farm tenancies and any other farm tenancies first? I mean, we're distinguishing between tobacco and any other farmer tenant. So if you are a tobacco farm, you get one law. If you farm corn or rice or beans or beets or whatever, you have a whole other set. Why are we distinguishing? I mean, I'll admit I'm not a tobacco farmer, so but I'm trying to understand why we distinguish tobacco farmers, why we call them out.
Oh, the references to tobacco farms is to reflect current law.
I'm sorry.
It's trying to reflect current law.
Well, why is it bold then if it's current law?
Because it deleted if you look at page 3, on line 30, beginning on line 36, that paragraph, in the parentheses, that's where the reference to tobacco farms come from.
So currently tobacco farms get what?
So currently they get 1 month. So the provisions of this subsection shall apply to all cases of tenancies at the expiration of the stated term, tenancies from year to year, and tenancies from month to month and week. In cases of tenancies from year to year, including tobacco farm tenancies, notice in writing shall be given 3 months before the expiration of the current year of the tenancy, except that in case of all other farm tenancies, the notice shall be given 6 months before the
Wait, that's
expiration.
the current law?
Yeah, that's current law.
That's on page what of the bill?
The bottom of page 3 and then on to page 4.
Our Southern Maryland guy knows the answer to tobacco farms.
So the reason that is when you harvest your tobacco in August, it goes into the barn, and it's in there for 3 or 4 months until it cures to when it can come out of there. So if you were leasing somebody's barn, and all of a sudden you said the guy did the lease, but there's nowhere to move that tobacco.
I just want to just say that was awesome. This is a value add, instant value add. That was awesome. Rolling off of police reform, now talking about tobacco. All right. All right.
Through 29 are just restating the current law. Okay. Well, it's a weird current law.
Correct.
So from what I'm hearing, some people in this committee have unreadiness with allowing long-term lessees for 2 and more years to have as much as 90 days notice before they have to uproot themselves and their family to move. Is that correct?
Not the way you put it, yes.
And I just want to say that these tend to be the more stable people, the more stable families that probably aren't presenting much of a problem. And I understand many of you may be really mobile people. One of the reasons I'm glad I don't rent is because I'm not. It would take a lot of effort, even though I'm even living alone, for me to move all of my belongings and find a new place within even 3 months. So I know that I can recall from when I first looked at the bill that this was the case in some other states. I'd be happy to find that. I don't have it right at my disposal right now, but it's not like we'd be the first state or creating something brand new. And so, I mean, I think from what I'm hearing, that's the biggest sticking point. You think that 90 days is too long a period of time to allow somebody to have if they've been in a place for more than 2 years or more. Is that correct? And if so, I also don't recall, but I'll check. I don't recall opposition from the property owners on that.
There is.
Okay, well,
You got the realtors opposed. You got Maryland Building Industry Association opposed. So you had 2 in
Was
opposition.
this part amended out? Was that amended out? Yeah, I'm trying to figure out where that is in the bill. So, like, AOBA came in favorable, and there's a couple sentences in their testimony. It says, this legislation only applies to the tenant holdover period and does not impact emergency lease termination, which speaks to a little bit of what Senator Huff was talking about a little earlier. The industry has long said that non-renewals of a lease for tenants that pay rent on time and abide by community rules are infrequent. While non-renewal occurs for the roughly 1% of residents each year, searching for new and appropriate housing is a process that takes time. As housing providers currently operating in Montgomery County and Baltimore City are already subject to local law requiring 60-day notice of their intent to terminate tenancy at the expiration of a lease, AOBA members find it reasonable to extend this requirement to residents across the state. So where is that in the, sorry, go ahead.
Section 8-402 is just dealing with holdovers. It's giving a notice to a holdover tenant. If you want to get an emergency eviction, like a tenant posing a danger, that's an entirely different section of the code.
That's super hard to use because I tried to fix that, and actually the bill got killed on the floor. But I know why the difference is, why you've got the Maryland Realtors, because they got people that only own like 1 or 2 properties. They're in a totally different situation. They might be taking them off the market. They're totally different. AOBA, they're giant apartment buildings. They're always going to be rentals. They're, that's a totally different situation. So that's why I would imagine you've got the realtors who are opposed to it, because they got the small guys that only maybe have 1 or 2 places, versus AOBA, they're giant apartment buildings. They're always going to be up for rent. What do they care?
So what are you good with?
I do think that that's a very, very important point. But Senator Hedelman, go ahead first. But then I want council just to kind of cleanly provide a clean explanation as to the holdover tenancies and what this is the only thing these are the only category of people in this holdover category that this bill applies to. But go ahead. Okay. So Senator Hedelman, you're okay.
Yeah, so sorry for the confusion. So this bill is only amending section 8-402 of the real property article, and that specifically deals with holdover tenants. A holdover tenant is a tenant who resides in the property after the expiration of the tenancy. So like if you have like a month to month, so like as soon as your periodic tenancy ends, so it's like technically a holdover, but it just converts to a periodic tenancy.
So this definition is provided if you look on page 5 of the House Bill 104 from lines 25 to 28. But most folks here know what the holdover period is. But go ahead, Senator Jackson.
From the early days in my work, typically the tenant holding over are actually paying the rent. The landlord wants the property back because they have a person who's going to come in and rent for at least a year or so. And so that's when the courts get involved to get that person out on a tenant holding over. So the tenant holding over person is typically a family, typically paying the rent. They're not just,
Does this bill doesn't apply in the city?
City already done it for 2 years. It's like, it's my understanding, City and Montgomery County already do the 2 years, like Jeff, like Vice Chair said, and that we were trying to create uniformity throughout the state, so that everybody did that.
It says this bill repeals Baltimore City, then here it says it doesn't apply.
Okay, all I know is Baltimore City does 60 days, and so does Montgomery.
So Senator Carter, I'm sorry, Senator Huff, you going?
Well, I guess that's the question. So I understand it because the front note says repeals statutory requirements of Montgomery County, repeals Baltimore City, and then but on page 5 it says this paragraph not apply to the city. So what are you exempting them from? So what's it doing what is it doing in its entirety to Baltimore City, Montgomery County?
It's making it uniform with the rest of the state. So I don't know what Baltimore City law
Do you
is.
see page 5, number 14?
Yes, so Can you repeat the question?
What does this part mean? On page 5 of the House bill, line number 14, this paragraph shall not apply in Baltimore City.
I'm not familiar with what Baltimore City's law is. I would have to look up how it differs from this, because on page 4, it does repeal a reference to Baltimore City and then also Montgomery County in lines 4 through 8 to make it uniform throughout the state. So I do not know what Baltimore City's specific law is in reference to paragraph 3.
Usually 60 days notice
So,
in the city.
I've said before, but probably not loud enough or something, that as Vice Chairman Waldstreicher said, going into this, it's my understanding that both Baltimore City and Montgomery County already had exactly what he said, the 60 days. And so what my belief is that we were creating uniformity with all of the other jurisdictions, what Baltimore City and Montgomery County already did.
Thank you, Mr. Chairman. So my proposal to compromise, so are we off that? I mean,
No, you didn't make a motion.
I'd like to make a motion for us to do, actually 45 days to 2 months. I mean, I think 3 is too long, so. Second.
I think you want, I don't know if you want to do that or you want to do what Jeff said. I think you're talking 40, instead of 45 days, Jeff's talking a 1 year versus 2 year lease.
2 months. That's
You're talking 2 months on a 2 year, right?
Yeah.
And then 30 days on a 1 year.
Yes.
Yeah, that's fine.
How's that different than the current, can you explain that again, please? I'm sorry.
Okay, they're looking for,
Jeff explained that Montgomery County does.
No, I thought he was saying 60 days.
He said 60 on a 2 year. But now we're confused because these are post people, so I
so we're
don't know.
looking, so. 45 on the 1 day? Yeah, I don't,
Shall be 2 months in the case of residential tenancies with a term of at least month to month, but less than from year to year. That's the Montgomery County, right?
so,
So it's 60 days for both of these provisions.
Correct.
Okay, so it would be 60 days before the lease expires, or if it was a holdover, 60 days.
Only tenants holding over.
Well, once the tenancy ends, it would be a holdover, so it's
So it's 60
the
days.
tenant under any periodic tenancy or at the expiration of a lease. Someone holding over the tenant shall unlawfully hold over beyond. So,
Can I ask a question, as a policy matter, why, and forgive me, but why is this, what's the purpose for only applying to the holdover category? What's the policy purpose? Is it because, sorry again, Castley.
I mean, you're only going when you extend it. If I do a lease that says, this is a 1 year lease, and it ends January 1st, and then you're gone, this is only applying where the lease has a renewal provision that says if it hasn't, it's going to roll over, because most leases have an automatic renewal provision that says it's going to roll over, but the landlord has a ability to stop that. So you're in essence a holding over. It's not, but you could still do a lease that says, look, I'm giving you 1 year, and then you're out. And so we're not extending that. If I give you a lease for a definite term that says this is a 1 year lease, no extensions, then I'm selling the house.
Got it. So this captures basically all folks, I mean, yes, okay.
Most of these things, you sign up for a month or 6 months or a year, and then it just keeps automatically renewing unless somebody gives notice. Is the typical thing is somebody, either the landlord or the tenant gives notice, which gets us back to the fairness issue, that there's no reason not to have it reciprocal, because the tenant ought to be able to say, I'm leaving as well, would make it a fairer bill. I don't see why the tenant wouldn't be bound by the same reciprocal notice provision, because otherwise the landlord is assuming the tenant's going to be there, and all of a sudden they pop smoke and they're out of there, and most of their, because I think what I'd be concerned is that by doing this, the courts say, well, we're precluding the landlords from putting in the lease that you have to give me 30 days notice or something, or it's an automatic renewal. And I wouldn't want those provisions to go out, because if we have people just taking off, because most of your leases are going to say, if you don't give notice within, 30 days before the end of the term, then it's going to automatically renew.
So, yeah, I think, if I'm not confused now, but I think the challenge was 30-day notice for 1 year. I'd originally proposed, 45 days. And for a 2-year lease, 60 days. Gives you a little bit more time. I mean, but I think that could be manageable. 30, correct?
30, okay, got it.
Yeah. And so if there's a challenge, I mean, you give them.
So you're meeting halfway for everything. pretty
Yeah, I
much.
mean, look,
You're halving everything.
so you're literally
halfway to everything.
Yeah, so you're literally preparing the place for the next tenant, anyway, and so that gives a person. I mean, if that's a challenge, I mean, I think the interesting thing is that the cross-filer of the bill was from Montgomery County, so right, I think. So what challenge is he trying to meet?
Well, I think, so to be honest with you, when I first had this conversation with the advocates as well as with the delegate that was the cross-file, it was regarding the situation in large part highlighted by the pandemic and the fact that even though there was a moratorium on evictions, unscrupulous landlords were using this tactic with only having to give 30 days notice, and some maybe not even that, to evict tenants, even if they were, because they wanted them out. So they weren't allowed to evict for failure to pay rent or any other reason, but they were using this non-renewal as a tactic. So I think that people believed, and I believe, that it was simply a protective measure for tenants that would keep them in their homes and from being evicted unscrupulously. So that's the goal. I was aware that we already had the 60 days notice in a couple of jurisdictions and thought that seemed like a fair thing to do.
So before we vote on this, it's been asked a couple times, and I'm not sure we got a definitive answer. Is there anything in statute that requires the tenant to give certain notice under current law?
I haven't found anything.
So, got it. If the answer is that that's not the case, we don't necessarily have to make it equal, but I just want the sponsor to be clear-eyed what's going to happen. If we require the landlord to provide additional notice, they will include in their lease that the tenant has to provide the equivalent notice. And that might not be so beneficial to tenants. To the extent that some of these tenants are unstable, and then you say, well, you have to give us 90-day notice if you're not going to renew the lease, or you're going to vacate the month to month. That's a lot of notice for someone who's unstable to give. And to the extent that what you're saying is true, that landlords are writing the lease, they will put the equivalents in the lease. I want to be careful about the unintended consequences here, because if we do something to landlords and don't spell out what the tenants are going to do, the landlords will do the same thing to the tenants that we are doing to them, and that could work to their disadvantage.
Unlike Senator Carter, I've rented a bunch from college on up, and I've never seen a lease that doesn't have at least 30 days. But I hear what you're saying. At least have the 30-day notice provision.
Right.
Yeah. Okay, Senator. I saw Hedelman first, then Bailey, but Unless, are you ready to go?
Yeah, I am. I believe these are just, so, right, the landlord must provide a 30-day notice right now. And I would propose making it 60 days and just keep it simple for both.
60 days for both.
Yeah.
Wait for the tenant and landlord?
No, not the tenant. I mean, just the
I'm just trying to
landlord.
understand, yeah.
Just the landlord. Well, I'm looking actually at the explanation.
2 months and 3 months.
And my understanding is that landlords already require tenants to provide more than 30 days notice in many cases. And so I would just, where it says sorry, I'm not looking at the line by line, but the 2 years or less and the 2 years or more, keep it consistent at 60 days. Right now, it's consistent, they have to give 1 month notice. What I would propose is put 60 days for both.
So this is some case law and some code about the termination of a tenancy by a tenant. So where a tenant has a written lease with a termination provision, the tenant must give notice of intent to vacate as required by the lease. A written lease may not require that the notice period given to the tenant is longer than the notice than the landlord. And then also, in a tenancy for a certain term, the common law rule is that no notice is necessary to terminate the tenancy at the expiration of the term fixed in the lease. And then in periodic tenancies, such as a month-to-month or week-to-week, where there is no written lease or no local law relating to notice from tenant to landlord, the common law requirement is that notice must be given and that the length of the notice must be equal to the period of the tenancy, such as 1 week or 1 month.
That would change
So, Heather, I definitely have probably some questions for you about this. If we go to the top of page 5, and it says if the parties do not have a written lease. So when we talk about written leases, and I know we talked about tobacco barns and things like that, but you know, when we talk about agricultural leases, right, there is something that still exists in case law. I've seen it used numerous times. My dad was a property attorney, based on a handshake. A handshake is a very serious commitment in the state of Maryland when we talk about property leases. They carry a year-long tenancy for farmers. And I have actually seen that litigated. So I want to make sure that when we put something in there about a written lease, that we're not doing away or affecting something that that deals with things that are already past proven practices, especially when we're dealing with rural area, with farmers, and with leases, that because of the fact when we talk about the expenses that they go through, whether it be fertilizer, lime, seed, issues like that, a lot of times they're having to plan for the completion of that growing season for that next crop. So it's a big deal that somebody would lose that right on a 21-day issue.
Danny, thank you. Yeah, so if you look at page 4 of the House bill, lines 23 through 29, Roman I and Roman 3, those are the two areas that deal with the farm tenancies. So Roman 2 deals with including the tobacco farm, and then Roman 3 is all other farm tenancies. What you are looking at on page 5, you need to go to page 4, line 30. In the case of tenancies from week to week, that's when whether it's written, not written, comes into. So if you have a farm tenancy that wasn't intended to be week to week, then that wouldn't come into play, that portion. So if you had an agreement that
That was my question, and my question is, I want to make sure that requiring a written lease for that 21 days does not have any bearing whatsoever on those other parts.
So the way I read it is Roman 4, in the case of a tenancy from week to week, that would exclude it because it's not a tenancy from week to week. You're talking about a tenancy that's longer.
Okay, I just want to make sure that we're not doing something that affects that.
I want to loop back to Senator Hedelman and Senator Jackson. So Senator Jackson had put forward 45. Senator Hedelman, you put I thought was reasonable in between 60 days. You said, can you just flesh out what your idea is? 60 days for the two periods of property continuously for 2 years or less, and then the second category has resided on the same property continuously for more than 2 years. Is that
Correct.
just? Can you flesh it out, or
Just
unless I?
I mean, just good characterization. It seems to me, look, I think that the tenant is, in these kinds of cases, has generally been there for a while and is in the community, and especially in the middle of a pandemic now, it's very difficult and may take more than 30 days to be able to accumulate all your stuff, to get your stuff together, to get out, to find a new place, and to be able to settle in. And I think, when we're dealing with a public health crisis right now, it is not unreasonable to give people an extension and to allow them some more flexibility and some more time.
Okay, so then the amendment would, so since we've adopted what the House did, the amendment would bring that second category down from 3 months to 2 months.
Correct.
And then the only thing that changes from the current law to now is
That.
the landlord-tenant, they do not have a written lease for a periodic term of week to week, which the current law says 1 week notice, and then the bill adjusts it up to 3 weeks. That still stays the same.
So 1 year, you got to get 2 months?
So right now it's 1 month, you just bumping
Is
it
that
up to
what's
2
being
months.
proposed? I don't want that.
It's 1 month now, it's bumping it up another 30 days.
No, because Senator Jackson made a great point on that. It's not truly even 2 months, because before you turn it over to another tenant or you sell it, you're going to need more time after that. So this person's really going to be out for, it's really almost 3 months then. I mean, look, if it's 1 year, 30 days, that's standard, that's fair. And the idea of COVID, COVID will hopefully be gone by, maybe this summer when everyone's vaccinated, but the idea we should be legislating, putting in law for the next 100 years because of COVID, 30 days on a 1 year is fair. That's totally standard.
Well, I would just say, in response to that, I would just say that the economic fallout and look, I don't know about your office, but my office has gotten an uptick in unemployment claims the past 2 weeks, an enormous one. And the housing issues are going to be here for quite a long time. So this is something we can revisit in a year or two, but I think that it is definitely worthwhile offering this extension in this period of time. I think it is a worthy policy change.
Well, I was kind of going to defer to the committee. I mean, it seems like there's a consensus that that people think 90 days is way too much notice for someone that has a stable family and children and has to uproot them even though they're paying their rent. So if I can't argue against that successfully, I will say that my initial understanding was actually that it would be a 60-day thing. I do think 60 days is reasonable. I recall hearing from someone, I'm not sure if it was a constituent, I think it was a constituent, as to Senator Hedelman said during this thing, where even though they received the notice from the landlord, it was the notice to vacate, it was that part of the time for the notice, the 30-day notice, had already run. So they got the notice that you have to leave in 30 days, but it was like 60 days. They got the notice that they leave in 60 days, but like 30 days of that had already run. So that's another issue, that even though in Baltimore City and Montgomery they might have 60 days already, if they aren't getting the notice promptly, it could also be a problem. So I would just surmise that I would go with the original bill, but I think at the very least the 60 days is a reasonable compromise, and I would urge the committee to go with that if you can't bring yourself to allow someone 90 days.
No, we got Further, we got.
Yes, so thank you, Mr. Chairman. So the reason look, a one-year lease is a person who, I mean, there are occasions where someone will say, hey, we think we want to be here 2 years. Do you have a 2-year lease? You sign a 2-year lease. If a person does 1 year, they have, in many cases, they're anticipating, moving to that next place or trying out the community. If 30 days is not sufficient, 45 is certainly enough. I mean, the key is, again, you've got to, so obviously we're looking out for the tenant, but we also need to look out for the person who's renting the property to be able to rent that property again and turn it back around. 45 on 1, 60 days on 2 and above. So.
I guess I'm not really understanding what the problem is with turning it over. Because if you know that if you as a landlord know that you have 60 days to find a new tenant, you're giving 60 days for someone else to find a new place, and and you can advertise and get another tenant. And unless there's like damage, which is a whole nother issue, you get a cleaning service in there in, 48 hours, and you could turn it over. What am I missing?
So, I mean, the answer is
new carpet in between each.
Yes. Well, you don't know that. You got.
I mean, can I ask Senator Jackson to answer that, please? I think he can say what he wants to say.
Thank you, Mr. Chairman. So I've been a landlord for a little bit, and you need a little bit of time to turn over the property. And I don't know where folks rent, but where I rent, you have to get the place re-inspected before you can rent it out again. We've been able to do that in 30 days. So we'll be able to do that in 45 days. But I could get someone back in because of the location of the property. You do have there are a list of folks that are waiting. I just think if you're doing if you're doing a 2-year lease, 60 days. 1-year lease, I think it keeps you concise. And if 30 days is a problem for the sponsor of the bill, add 15 days to it. So, look, it's up to. I try to make a compromise with the maker of the bill. Obviously, it's her call. I think 45 and 60 makes sense.
But then we'll run it. So at 60.
Thank you for everybody so willing to compromise. I stated this before, but maybe it bears restating that landlords were using this as a tactic to get people evicted, even though there was an order in place preventing evictions. It was a loophole that was being used to get people out of their homes. These aren't necessarily recalcitrant tenants, bad tenants. And when we talk about, while I empathize with Senator Jackson and other people that are fortunate enough to be landlords, they're talking about somewhat of a potential inconvenience or a potential loss of money. But this is about keeping a roof over people's heads, keeping people in their homes. And I think that the need to do that somewhat outweighs the potential loss of profit for 15 days or whatever we're talking. And so again, it's apples and oranges. You're talking about preventing homelessness, keeping children in their homes and off the street and out of homeless shelters versus a potential loss of profit. I really don't think that it's unreasonable to move to the 60 days, which is already being done in Baltimore City and Montgomery County. And as I said, even in Baltimore City with the 60 days, I'd gotten information from a constituent that even that was being abused. So I think that 60 days is reasonable. I'd argue for it. Of course, it'd be the will of the committee. Thank you.
Yeah, just real quick, look, the point that was made earlier that about COVID, the more I hear the bill, and I'm not opposed to giving people some buffers there, but those buffers exist. This law is not necessary. This entire bill is not necessary. COVID is really close to behind us. There's a reason that we have a lot of local laws on landlord-tenant issues, because courts do things different ways, landlords do things different ways. If you want a local bill on something like this, I say have at it, but to force statewide changes, because I can tell you, in my county, that loophole wasn't there. People weren't being put out. They just weren't hearing cases at all, and the courts were not doing that. So I'm not sure why we need the bill. By the time this becomes effective, this whole issue is going to be behind us. And if it's truly for COVID, let's just put a sunset on it for 6 months or something. My other issue is on page 5, the bottom of page 4, top of page 5. If it's a written week-to-week lease, you get 7 days. If it's an oral written week-to-week, if it's an oral week-to-week lease, you get 21 days. I don't understand any rational purpose between if it was a week-to-week lease, that means you're in somebody's house. I mean, you just don't do week-to-week for an apartment or a house. A week-to-week would mean you got a room in my house. I told you it's week-to-week. Moving out doesn't involve moving furniture and all that. So I would suggest that if absent some rational reason to distinguish, that a week's notice, as is at the bottom of page 4, should be plenty for either a written or oral lease for week to week. Thank you.
Well, look, it's up to the maker of the bill. I mean, I think Senator Carter said she's good with 60. I think 45 works from a practical standpoint. I've lived it, I've done it, but it's up to Senator Carter. If Senator Carter, between year 1 and year 2, have a 1-year lease and a 2-year lease. I think there should be some distinction, but that's me.
On a 1 year, I mean, we should not change. It's just common practice everywhere. 1 year is a 30-day. And then the idea that if you go to sell the property, it can take a whole month to get through all your inspections. You got to have everyone, if you're going to sell it, you got to have radon inspections. You got to have, the place has lead paint. You got to get all those inspections. And inspections always then, you have to fix things. You have to go back and get it all repaired and go through having the house up. I mean, it takes a month to easily get a house through all that stuff.
I've repeated several times, and I'm just going to say it one more time. I hear what you're saying, but the 60 days is already the practice in Baltimore and Montgomery County, so clearly it's not a horrific problem. Also, this is also the case in some other states that actually go to the whole 90, so
That's not what it says here. It says current law, 1 month.
It's 60 days.
The state.
No, those two are exceptions.
Yeah, I understand. I'm reading the state law. So maybe Baltimore County can pass its own. Maybe you can go to Baltimore County and get them to pass a 2, 3 month, 4 month. What's best for Baltimore County?
What Senator Carter is saying is right, and what you're saying, I guess, is right as well. But yeah, you're right. Montgomery County, there's 60 days.
Yeah, I'm reading the state. I'm reading the state law.
Yeah.
30 days.
I know, but you're both right. Just so you know, like Montgomery County and Baltimore County have gone forward and added 30 additional. Yeah.
Law is 60. The current law is 30 days. And guess what? All these advocates can go to all these counties and get them to change it. Instead of coming here and making us do a one-size-fits-all solution. I know that's harder. It's easier to come here and get us to jam all local governments and make it 60 days. They could go to Frederick County, they could go to Baltimore County, they could go to Hartford County and get them to change the law. But no, it's easier to come here and use COVID as an excuse to jam this through. And by the way, with all the evictions, how are all these evictions? The courts have been closed. Where are all these evictions? The courts have been closed. How are they evicting anybody? The whole sides of this, it's getting frustrated, this landlord-tenant, because it's always the tenant. What about the landlord? You don't think they're suffering right now? You don't think these people are suffering? What if they're not getting rent for like a year? They can't evict them. The courts are closed. And then to sit here and set up this one-sided equation. Hold on. All these bills are completely biased, totally against the landlord. As the vice chair was saying earlier, they have a 1 month, I'm out. They're going to provide 1 month, I'm out. The landlord now will have to give 2 months back. So it's not fair what we're doing. This is totally unbalanced what we're doing. And there's two sides to the story. There's a lot of landlords who are small. They're not AOBA that own giant apartment buildings who are really suffering. And how are they evicting anybody? The courts are all closed.
All right, Senator Bailey, and then we'll go back to Senator Carter. And
So just on this same vein that we were talking about, and I have a lot of the people that I are friends with, I represent, they rent their houses. And the reason they do that is to earn money. It is an income for them. They are doing that to help their family. It is clearly their second income. And I think that at certain times, the government is an overreach when we say, well, you know what? You have the ability to rent a home. It's your obligation to stop homelessness because you're doing that. Don't worry about that 15 days that you could be earning money. I think we need to think about the people that actually own these houses and the jobs that they are doing.
So I just want to clarify so everyone understands what Montgomery County's law is. It does not apply to single-family homes. It only applies to multi-family units. And so they make that distinction locally. So in Senator Castley's example, in Montgomery County, you'd only have to give 30 days if someone was renting space in your house, but you'd have to give 60 days if they rented an apartment as part of a larger apartment building. So I just wanted to be precise about how we describe what the local laws are. Montgomery County and Baltimore City may be different in that regard, but I know Montgomery County specifically exempts out single-family homes.
Frankly, I don't want to keep going back and forth, but I keep hearing things that seem to warrant a response. So with respect to what Senator Huff was arguing, the whole point of the bill was that even though there was ostensibly a moratorium on these evictions, they were still happening because it wasn't a blanket moratorium. Landlords were using this, and then the COVID thing was an affirmative defense the tenant would have to use to try to stay in the home if they wanted to stay in the home. It wasn't just a blanket, you can't file an eviction. It was that tenants had to defend in a way that was successful. But to get out of the defense of I can't pay the rent because I've lost the job because of COVID or I'm in unemployment or whatever, they were using this tactic as simply failing to renew, and notice was sketchy. And I want to be clear that maybe some landlords weren't doing it in this way, but it was the bad landlords that were creating a problem and that we have a responsibility to protect people against, and that's what I think that the goal of this bill is to do.
Thank you, Mr. Chairman. I wanted to make that point. It's not technically an eviction because they're not going to court and filing there, but it is in effect one by non-renewal of lease. And so that's how these have been happening recently. 2 is the courts opened yesterday, and so these are coming. And 3 is our job is to make statewide policy, and I think it's perfectly appropriate and landlord-tenant for us to be making statewide policy as the senator from Baltimore City is trying to do through this bill. Thank you.
So there's only one way to get a tenant out, and that is through the courts. We've taken the other options away. The landlord cannot lock the door. They can't boot the tenant. So you do have to go to court. That's how you do it. And answering Senator Carter's position, look, there is a reason that we have local bars. It's in bar associations. It's because each county is different, and the judges do work with the lawyers. I can assure you, in my county, for example, we accepted pretty clearly that under the law, under the federal statute that was, the federal directive that was issued, if a tenant simply said, I'm having COVID problems, COVID-related problems, it was pretty generic, and the landlord moved forward, the landlord was facing some horrible potential fallback in the terms of a federal lawsuit. So this was not an easy go-around. The tenant, it wasn't like a sort of a BS defense that the tenant would have to put out and probably wouldn't win. It was a really tough hurdle for the landlord to cross. And, I'm sure somewhere in certain courts in this state, people looked at things differently. But that's the reason you have local laws, because the housing market is different, the courts are different, the needs are different, and we've been fairly, the fact that we're sitting here looking at the differences between Baltimore City and Montgomery County right now, it's with good reason. Some people do rentals in houses, others would never. No, some places don't do that at all. Some are renting nice big homes. Some are renting very small row homes. Some are renting cheaper apartments. Some are renting big high-end garden apartments. And so the locals have the ability to tailor the remedy. And sure, we can push big statewide policies uniformly throughout the state, but that's not always the best way to do it. Yeah, we can do that. We can force ourselves and say, hey, we're God, and push it out. But very often, giving the locals the ability to tailor this, you end up with a better result. And because they can exactly tailor the law to what their market, what their local practices are, what their local courts are doing, and the like. So I really think that we've crossed the line here as to where we need to have a uniform statewide policies. Thank you.
Just a quick question for council. Thank you. Just could you tell us the posture of this bill over in the House, where it is?
So in your packet,
We
it
have
was it's House Bill 104, which I had written Senate Bill 401 at the top. So it was included in your packet.
No. What I'm asking is has it passed out of its
Yes.
standing committee?
Yeah, it's in JPR now.
It's here.
Yes.
Yeah.
Thank you.
Statewide policy that it's 30 days right now, right? I mean, statewide law, it's law across the state. So we have seen, we have seen that it is worthy of the state to make a policy on 30 days. All she's trying to do is change it. That was my only point. Thank you.
Senator Hedelman, you still have your amendment? Okay. So this
I defer to the sponsor of the bill. If she wants to run it as it is, that's up to, I defer to the sponsor.
So you're withdrawing the amendment? Or the,
I'm not sure which amendment.
so she has amendment for 60 days. For the, if you have your cheat sheet here, it's the first two categories. So it's correct. 60 days across for both categories here. So for month-to-month tenant that has resided on the same property continuously for more than 2 years, and then the top portion right here, month-to-month, and the tenant has resided on the same property continuously for 2 years or less.
This is more, this is farther than the house went, right?
No, the house went to 3 months, and she's proposing 2 months.
Oh, I see, Bill, 2 months.
The House was 90 days, this would be 60 days across the board, right? Is that correct? Then, no, I would take that amendment.
So you made it.
Second.
Okay, Senator, it's been seconded. It's before us.
I'm sorry, just want to clarify. So I'm looking at the House Bill 104, and if I look at that on page 4, what we're changing is basically line 20, it says 90, we change that to 60. Is that the amendment?
Yes.
Just right there, that's the amendment, okay. You want to look? Page 4, line 20.
from the current law, you're upping it 30 days.
Yeah, it's terrible.
Senator Cassidy, go ahead.
No, I second her. She took it from 90 to 60. That's better than 90.
30 to 60 on a one-year lease?
No, she just took it from, the only amendment right now is to take the,
Amendment goes the one-year lease is 30 days. She takes it to 60.
no, what we just amended was on the House bill, page 4, line 20, it currently says 90.
Ask them what we're doing on the amendment. Yeah, just ask the chair for clarification.
Oh, so the amendment that, as I understand, that was just adopted, so page, or sorry, the proposed one is page 4, line 17, that remains 60 days. And then page 4, line 20, that will be 60 days.
Yeah, so the 1 year is going to 60, correct?
Technically, we're not working off the House bill. This is the Senate bill that we're going to pass.
Yeah, yeah, I just because it was the reprint is why we're
Can you answer?
She seems confused.
So 30 days, not going to 60 days to get them out.
You look at House Bill 104, page 4.
I just asked for clarification. I'm not looking, I just asked for clarification.
Sorry. Senator Huff, can you repeat your question, please?
All right. I keep asking the chair, and he keeps saying I'm right. That Senator Heldman's amendment on a one-year lease takes the current law from 30 days to 60 days. Yes. And that's what I'm saying is bad policy. That's why I don't want that at all.
You have the amendment. It's been seconded. So from current law, it bumps it up to 30 days. From the proposal, as it came in, it drops it down 30 days.
We adopted an amendment, I thought we adopted the House bill, right? So currently, what's sitting before this committee is not 30 days, it's 90 days. Right? We adopted,
Yes.
We didn't adopt the House bill.
I thought we
did?
conformed the House bill. So what's currently before the committee is the version that is House Bill 104.
When
And on
did we do
page
that?
4, on page 4, that currently says 90 days, and the senator's amendment is taken from 90 down to
Yeah.
60.
Which, you don't want that. You take that 60, or else we stuck with 60. You think, no, don't walk over. You think you're improving it. Look,
I vote for the change.
We're going to roll it.
Vice Chair Waldstraker.
Yes.
Because you're going to pass
Senator Lee.
Yes.
You just passed the bill.
Senator Castle.
Yes.
Senator Hedelman.
Yes.
Senator West.
Pass.
Senator Sidnor.
Yes.
Senator Jackson.
No.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff.
No.
Senator West.
No.
Chairman Smith.
Yes. All right.
Amendment passes.
All right. So now the bill's before you as amended. Further discussion, or do you want? We all know what the bill does now. Senator Carter.
Yes,
So it's been seconded. So we'll roll it. Roll call.
Vice Chair Waldstraker.
Yes.
Senator Lee.
Yes.
Senator Castle.
No.
Senator Hedelman.
Yes.
Senator West.
No.
Senator Sidnor.
Yes.
Senator Jackson.
No.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff.
No.
Chairman Smith.
Yes.
6-5, bill passes.
6-5 bill passes as amended. Okay, with amendments. All right. We got time for. Let's. Do we do the dim credits yet? 390. Let's do that. Huh? Senator Lee, go ahead. You want to do 623?
Simple bill. It's the ransomware bill. Okay. There's just one amendment, and to conform it to the House version.
What was that? That's, council has that. That's Jamie? All right, so can you explain the bill?
Thank you, Mr. Chairman. Senate Bill 623 prohibits a person from knowingly possessing ransomware with the intent to use the ransomware for the purpose of introduction into a computer network, or computer system of another person without authorization of the other person. It also prohibits committing a ransomware offense or other prohibited act under current law with the intent to interrupt or impair the functioning of a healthcare facility or a public school. It also alters existing monetary penalties for specific computer-related offenses.
I have a question on this bill.
Yep. Senator Huff?
Is this the same bill that's been in here like 4 years?
Yes.
And
a
this is-
version of this has been in there.
And this is a bill, we never pass it because it's already a crime.
Cannot knowing, this makes the possession, the intentional possession of ransomware a crime, a misdemeanor with up to 3 years and a maximum fine of $10,000. But now we're going to amend it to 2 years with a maximum fine of $10,000.
So,
The difference is, too, we're also amending current law to include in critical infrastructure hospitals and schools, and to amend the amount of loss of $10,000 and make it a felony, punishable up to 10 years, and a maximum fine of $100,000. And we leave the existing amount misdemeanor penalty if it's less than aggregate loss of $10,000 to 5 years and a $25,000 fine.
so this is a bill that the mere possession of quote-unquote ransomware, whatever that is now a felony.
No, the intentional knowingly possession of ransomware with intent to use it and to introduce it into a computer system is a misdemeanor. This is mirrored after a law that was passed in Michigan. The reason why you want to make it a criminal penalty, because it's been on a huge surge in ransomware use. As you remember, the Baltimore city government was attacked. It was shut down for weeks. They incurred losses of about $8 million. The Salisbury Police Department was attacked. Baltimore County School System was attacked. Several hospitals were attacked, and they've been using ransomware. It's a very easy piece of software that you can get on the dark web to shut down a whole entire computer system. And the reason we're making it the intentional possession with the intent to use it for malicious purposes is we're trying to have a proactive tool to prevent and deter the use of ransomware for that purpose. There is an exception unless it's for research purposes. And then we're amending the current law dealing with attacks against computer systems involving a hospital or a school system. Right now, the current law has public utilities covered, something that we passed in 2009. And it passed the House overwhelmingly. There was no opposition, and but they just wanted to amend it for the possession, the intentional possession, to 2 years instead of 3, and a fine of $5,000 instead of $10,000. That's the only changes they made, which is fine. That's fine with me. It was a nice compromise. Michael, the bill that was introduced like years ago was an extortion bill. And Chairman Zirkin Yeah.
Was not the, I remember that bill. I was confused at first, but this one, it's now come back to me. The issue was ransomware. What is that? The issue was like there was First Amendment stuff and the anarchist cookbook they were talking about, and then how do you prove the intent? So that's why, that was my memory of the debate and the hang up on this in the previous years.
Yes, so I got an Attorney General's opinion on this just to provide a little bit more clarity, because you're exactly right. Remember I brought up the anarchist cookbook, like mere possession, or like how do you prove the intent? So I did, counsel, can you outline what was in the Attorney General's opinion with respect to the First Amendment issues?
So the AG responded that while there wasn't any controlling case law indicating that this prohibition would be unconstitutional, there was a risk that a court could determine that the bill's prohibition against knowing possession of ransomware with intent to introduce it without authorization restricts protected speech. The AG did note that previously courts have determined that computer code there are instances where it's protected speech, and therefore would restrictions would be subject to strict scrutiny to uphold them. But I guess the AG had pointed out that in Nevada there was a case where I believe a district court had ruled that a defendant's guidance of his co-defendants in developing malware as a means of harvesting stolen data as part of an identity theft conspiracy likely did not constitute protected speech within the meaning of the First Amendment. So I think in sum it was that it could present constitutional issues, but that there wasn't anything clearly unconstitutional about it.
That's my favorite AG opinion.
Okay, Jamie and esteemed committee members, this language about the possession, intentional possession of ransomware, it was modeled pretty much close to a law that passed in Michigan years ago, and so far, since that law has been in operation, there has been no First Amendment challenges. I think this is an important step to give our state's attorneys the ability to go after those who want to use ransomware and to prevent a huge attack against a hospital or a police force or a whole city government. Right now, a lot of the attacks are local, and they're going after entities that are vital infrastructures. And so this is a tool to give prosecutors ability to deter the use of ransomware, which is on the increase. Just between 2008 and 2019, they experienced a 41% increase in ransomware. And you can easily purchase the software that is used to create ransomware on the dark web. And there's tons of incidences where this has happened. And Jamie, did you want to point out the articles in there?
I guess I was going to recap what you had mentioned about Michigan statute. Michigan statute evidently prohibits a person from knowingly possessing ransomware with the intent to use or employ the ransomware for the purpose of introduction onto a computer data, computer system, network, etc. So I did just want to recap that. I'm not sure about and haven't looked into any situations where it may have been challenged, so I don't have any information there.
They had been a subject of a ransomware attack as
Right.
well, the state's attorneys. And they indicated in their testimony that they said that the feds won't give them cases unless we have a state law first.
I don't recall that, but I guess to follow up on something that you had pointed out just a moment ago, I guess in past years there had been a question about the level of sophistication and how widespread this was, whether it was something that would be concentrated in numbers of just a few actors who were extremely sophisticated conducting hacking attacks or ransomware attacks, or if you could have less sophisticated actors who may not know much about computers conducting the attacks. And I did come across some information from, there was a Bloomberg article and a couple of other articles that addressed that on the dark web, it is possible to obtain ransomware through what's being called ransomware as a service. So people can actually contact programmers who are more experienced, obtain the ransomware, and a platform to actually launch the attacks themselves and demand money. So I did want to follow up on that.
So I agree with the sponsor that this is a terrible problem and getting worse. I'm not sure the language is tight enough to address what the sponsor wants to address. Under the First Amendment analysis that the Attorney General did, there was a Nevada case that the council mentioned. And in the Nevada case, there was an affirmative step that turned the protected First Amendment speech into something criminal. And this bill doesn't require that affirmative step. For someone who I know you care deeply about the First Amendment, as do I, but if we're looking to be especially careful about legislating what could be perceived as protected speech, we need to require some type of affirmative step, even if that step isn't a completion step. That affirmative step idea is constant throughout the law, but absent in the statute as written. So I also pulled up the Michigan statute, as did council, but what I found was an article that indicated that cybersecurity professionals were very scared of the new law in Michigan because they were worried that it would criminalize what they do for a living, which is to sample malware, to understand malware, to have malware on their own computers.
There's an exception in this that research purposes are exempt.
Right, but I read the research to mean academic research. Like University of Maryland, they're doing research on it, but there's a whole industry of private professionals who are doing this for profit, who would probably not be defined as researchers, that would rather be defined as cybersecurity professionals who do this for a living, have this stuff on their computer, and we wouldn't want to chill their ability to prevent these attacks.
Because I think that would be within research purposes. And I think they didn't want to, they wanted to allow some flexibility. And that's why they did that in Michigan and put in that exception for research purposes. Unless you can come up with some amendment to, I don't know how else you would do it. I don't think that there is that danger that you perceive.
Thank you, Mr. Chair. I look at the language in the new, on page 4 in lines 25 to 28, Senator Waldstreicher, and the crime is knowingly possessing ransomware with the intent to use the ransomware for the purpose of introduction into the computer network of somebody else without the authorization of the other person. I can't believe that professional cybersecurity people intend to introduce stuff into other people's computers without their permission, and if they were to want to do that, I don't think we should permit it. So I don't see any, just as we don't permit people to have child pornography on their computers, and the mere existence of child pornography on a computer is a crime and is not protected by the First Amendment, it seems to me the existence of ransomware on your computer with the intent to use it to hurt other people's computers without their permission, that should be a crime. I have no problem with this bill. Frankly, I would increase the penalties, but I'm willing to live with it the way it is.
Thank you, Mr. Chairman. Prior to coming to the Senate, I served as the joint chair for cyber and information technology and biotech. And we opened up the sessions for anyone who was interested in bringing a bill before the Cybersecurity Committee. And I like the bill, Senator. This was a bill that we were willing to take on. There are so many challenges that we have, aside from that committee has too broad of a scope. I think there's something we need to talk about. Cyber is going to be something that's going to be with us for quite a while. And I think what we're going to find out of this pandemic is that we are probably going to find more things that have happened afterwards since we've been living in this COVID environment. I think there's some, obviously, there may be some terminology issues or some minor issues, but I think the intent, I understand the intent. I remember the presentation, so supportive.
And I thought it was a good work product, and it's a work product of the Maryland Cybersecurity Council, which is chaired by the Attorney General.
So, in response to Senator West's concerns, I'd like you to just look on page 3 of the reprint at line 24, and we already make it illegal for a person intentionally, willfully, or without authorization to access, attempt to access, cause to be accessed, or exceed the person's authorized access to all or part of any computer network with the intention to do something bad. So then we go, but apparently that's not good enough for the folks that are sponsoring this bill. Those seem pretty clear cut. Now we have to go, then you go to page 4, and it says, page 4, line 25, a person may not knowingly possess ransomware, 26, with the intent. So I can't imagine any proof of intent that I would be comfortable with that would not also sat under page 4, line 26. I cannot imagine any intent or evidence of intent that I would be comfortable with to show that which would not already would not already have caused a violation on page 3, line 26, to access, attempt to access, or cause to be accessed. That gets to the chilling effect that Senator Waldstreicher mentioned, because unlike child pornography, there is a legitimate business reason for a lot of people to have this malware on their computer so they can do Norton scans, develop stuff for Norton scans and all the other scans to figure out what's your malware, to defeat malware. So there's no legitimate purpose for anybody to have child pornography on their computer, but there is a legitimate reason to have malware on your computer that's not nefarious. And now I'm in a compromised position because I'm a person who does that, and you're going to somehow somebody can devise an intent for me to do something nefarious without showing that I accessed, I attempted to access, I caused to be accessed, or I exceeded my authorization, or anything. There's some level of intent, because if it was, we'd say, hey, we're already there. We got page 3, line 25, 26. We've already got you nailed, bud. No, we want something different than that. It's a much lesser showing, and that's why there's a chill, because you're going to somehow divine an intent by me to do something bad from the fact I have it. To me, that's scary. That's what we call a chilling effect on legitimate commerce. So I can't support this. Thank you.
Exception for the research purposes, and I think that takes care of that.
I think when you get back to Senator Walter, research purposes is academic. I'm possessing this for business purposes. If your job is you get that malware and you go through it and you figure out what you want to do, and then you email it to your buddies at Norton and you make big money because you just showed Norton how to defeat this malware, and they make money off of it. It's a legitimate reason, and so that's why you don't want to chill that, because somebody would have it on their computer, and they would face scrutiny that they would have to go to jail for simply having it.
That's not use for malicious purposes.
So we've got at least one, you have an amendment, you said?
To change it to the what the House passed out. So that just alters the penalties. So under the bill, the penalty as it came in was 3 years for the possession. So this actually brings that down to 2, and it takes the $10,000 fine as it was drafted and drops it to a $5,000. So that's page 5 of 6 of the reprint, lines 14 through 16.
I know that I've heard at least one amendment being prepared to talk about kind of like legitimate business use to address that issue. We'll adopt this amendment, and then we are well over our time, so we're gonna have to come back and do this. So we're gonna adopt the amendment, and then we'll reconvene tomorrow after our hearings for voting. Okay, is everyone okay adopting the amendment to conform it? Okay, great. So we're well over our time, so we'll bring this back up tomorrow. All right, thank you.